Thank you. I would request Professor Dr. Sanjay Singh sir to present our guest of honor with a bouquet of flowers. Thank you, sir. I would request Professor Dr. Neeta Bedi ma'am to present some memento to our esteemed guests. Thank you very much, ma'am. Now I would like to call upon Professor Dr. Sanjay Singh sir to conclude the program with his words. Sir, please.
Respected retired Justice J.D. Kapoor, Delhi High Court, Delhi. यहाँ पर उपस्थित डायरेक्टर कॉर्पोरेट अफेयर्स मिस्टर युमान सर, डीन स्कूल ऑफ लॉ डॉक्टर नीता बेदी, प्रोफेसर डॉक्टर दिनेश बाबू, HOD डॉक्टर पुष्पराज, डॉक्टर JPR and faculty members and students. सबसे पहले मैं जस्टिस साहब का दिल से आभार प्रकट करता हूं कि उन्होंने अपने बिजी शेड्यूल में से बड़ी मुद्दतों से हम प्रयास कर रहे थे कि सरकार में थोड़ा सा समय मिल जाए और वो समय उन्होंने हमें दिया। हार्टली थैंक्स सर। हम आपके अमूल्य योगदान के लिए सदैव आभारी रहेंगे। और आज जो उनका टॉपिक है कंज्यूमर राइट्स एंड बेनिफिट्स, वो थोड़ा करेंट टॉपिक भी है और हमारे लॉ स्टूडेंट्स के लिए काफी महत्वपूर्ण है। तो प्लीज आप थोड़ा सा डिसिप्लिन भी बनाए रखेंगे और धैर्यपूर्वक उनके गेस्ट लेक्चर में पूरा अनुभव प्रदान करेंगे। थैंक यू सर।
Thank you very much, sir. Today we have with us retired Justice J.D. Kapoor, sir. He is known for his high disposal of cases and a large number of admirable judgments, which have been reported in various law journals. His books on marriage and contempt of court have been a source of great significance.
After having served for 4 years at the bar, he joined State Judicial Service in 1970 and has spent over 30 years as a member of Delhi Judicial Service and Delhi High Judicial Service before his elevation to Judge of Delhi High Court. He has held various significant positions such as Rent Controller, Matrimonial Judge, Special Judge for Dowry Theft Cases, and Rent Controller Tribunal Secretary. After his retirement as Judge of Delhi High Court in April 2004, he was appointed President of State Consumer Disputes Redressal Commission, Delhi. Sir, thank you for accepting our invitation. It is an honor for us to have you here today. I'm sure we all are looking forward for a knowledge-acquiring session. So without delay, I would like to invite Justice Kapoor sir to the podium. Sir, please.
Thank you. Honorable Dr. Sanjay Singh, Madam Bedi, faculty members, and the future protectors of interests of justice of the citizens at large in this country. You know that there were 2 noble professions known since the time immemorial in the world. One was law and another was medicine. The law was a noble profession because of just serving the interests of justice of the citizenry at large, oppressed and suppressed people, and coming to the rescue, the succor of the of their miseries. And medicine was known as a this noble profession because they serve the interests of humanity. They provide succor to those who are in disease and all that, and they are just seeking life. So, in our times, I don't know, the law used to be the last option. But the times have changed. As society, society is steady, either it change through evolution or through revolution. Similarly, no state, no life, no discipline is steady. It goes on changing. Law particularly goes on changing through evolution and particularly interpretative evolution. Therefore, the law is nothing but a common sense. You have given law courts in the world only to give the information about certain laws governing the people at large and rule of law, that's why they say that. But so far as the legal knowledge is concerned, it has to be imbibed through developing your common sense. Common sense is very uncommon. Incisive mind, children your imagination, your analytical power to synthesize how you will come up in the world on your own innovativeness. This is the only profession in the world which can reach out the ethics and culmination of the intellectual pursuits of an individual or any person belonging to any discipline. Because as a lawyer, you will be facing so many difficulties and so many problems like medicine, science, and everybody will come down to door. And you will have to imbibe so much depth into the knowledge of that particular discipline that you are expected to know more than what the doctor knows if a doctor approaches you for some lesson of his own discipline and science. So this is the only profession which encompasses in its whole and embraces each and every aspect of human life. Because every aspect of human life or a day-to-day human life is governed by law. Nobody is untouched by law. That is why they say that no democratic society can survive without existence of rule of law. The rule of law is so important that in the world, if the rule of law collapses, the entire civilization, cultural empire will collapse. So you are now those future of the nation who are expected to serve the interests of justice. Nowadays, you have so many open vistas. There are so many vistas open to the law students because that's why I'm finding that large number of students are joining law. Earlier, the last option used to be the law, now seems the first option of law, and many intelligent students getting higher marks, they're also joining law. There is a new opening. Why? Because there are a large number of openings for the law students, which earlier never used to be solved. Therefore, you should, earlier they say that, oh, you are doing law, you will not survive. So is the case today also, but hard work always pays. There is no shortcut to any success. There is no shortcut to hard work. That's why English say, Vidyarthina kuto sukha sukhatina kuto vidya. If you want to have good education, acquire knowledge, be of all the. Because law students are not only to know about the legal provisions of law, particular specific law, like CRPC, Evidence Act and all that. No. In the olden days in Britain, there used to be no law courses. There used to be like Blackstone lectures. Only lectures through lectures they used to develop the mind of the young graduates. They used to train their mind incisive, make their mind so incisive that it used to be razor sharp, so that you can go down and have the teeth more deeply into the meat of reality, whatever subject you are encountered with or whatever problems you are facing. That's why they say that in England also, they are having many committees to evolve the quality of legal education. The quality of legal education is certain significance and certain importance that the future judges and the future lawyers and the health of the future nation world of legal education. From time to time, we have been having so many committees for evaluating how to improve the legal education in the world. The last such committee for England was All About Committee in 1957 or 56, and they published a report which was well received all over the world, and many of the countries have accepted and they want more than that what they were used to say. They say that no, law subjects information is one thing, but non-law subjects are more important. Literature, you must be having full knowledge of literature, be it English literature and all that. Non-law subjects provide and open your mind and develop your mind to such an extent that you can be innovative, you can be original in thoughts and not on the time run of the mill or run of the judges. That's the legal education quality. If you are not having good judges, it's because of the poor quality. If you are not having good lawyers, because of the poor quality of legal education. So therefore, from time to time, all the institutions have been impressing upon how to improve the legal education. Nowadays you have so many openings. I will just tell you about the consumer law, which is a daunting law. It was way back when the March 1985 that the United Nations General Assembly passed a resolution asking all the developing countries to take care of these consumers' interests of their citizens at large and the population at large, because all these developing countries were facing unscrupulous traders, service providers, manufacturers, distributors who were paying with their lives and they were taking them for our lives. And that was why India was the first country to adopt the resolution of the United Nations General Assembly way back in 1986 by passing the Consumer Protection Act 1986. The preamble of the act was to take better protection of the interests of consumers. There was ethical, inculcate ethical values in the service providers, manufacturers, distributors and all that, because every one of us, however high one may be, to whichever discipline of one walk of life may belong to, is a consumer in one form or the other. When we wake up in the morning until we go back, we become consumers of each and every goods consumed by us, used by us, each and every item. So inculcate those values in these unscrupulous people, rich and powerful business houses. This law was enacted. This is the model law of the world. I have not come across any perfect law, any best law than this law, because when I was heading this consumer commission, I had to develop the consumer jurisprudence through this law. To such an extent, the various countries of the world, with Canada, with England, with Malaysia or Singapore, used to take cues from those judgments and how beautifully this law has preserved and protected the interest of the consumers at large. The definition provided and the remedies provided under this law was so vast. And so that's why I'm saying that the legal knowledge or legal mind should be such that it should reach the pinnacle and apex of the intellectualism. Until you develop that mind, you interpret each and every sentence to such an extent that lawyers are known to evolve English language used like this in the legal language. English language is a very powerful language. Every word has many shades of meaning. How to use which word where in what circumstances, it changes the whole face. It changes the whole eternity of every problem or every provision of law. Terms of a contract for license and all that. Like insurance laws, aviation laws and all that. The interpretation of aviation laws done by me changed the entire international law and the aviation laws. That was Kandahar hijacking case. I'm just telling you what is the interpretative mind of the legal mind. Kandahar hijacking case. The House of Lords gave a ruling because that time there is a special lecture of mine on the interpretation of statutes before the international gathering or international seminar every year. in the parliament and exit. They said that there is a law that embarking and disembarking are inside aeroplane. If you suffer any injury, you are liable to be compensated by the airlines for deficiency of service. Our first 12 Act, two words, defect and deficiency. Defect, what is the meaning of defect? Defect has been defined by the Consumer Protection Law. Any shortcoming, any inadequacy, any imperfection in the quality and purity of any substance or any food to be used and consumed by the consumers. Any, word any is very important. Similarly, any service which is being used by potential users comes within the ambit and within the arena of the consumer laws. Dictionary meaning of the word any is some, one, all. Some, one, and all. That is the rules of interpretation, the golden rule of the interpretation is that every lawyer or a judge should interpret every provision of law, every term of the contract, be it insurance contract, be it flight contract, be it house building contract, every term of the contract should be interpreted in a manner so that it should serve its purpose, promote its object. And if there are 2 or 3 interpretations possible as is being done by several lawyers to the court hours, then interpretation which serves the purpose, which protects the interest of the consumers has to be adopted and accepted, no other interpretation. So this is the golden principle of interpretation of statutes, that the interpretation which should serve its purpose, for whom it was made, for whose interest it was to be protected, only that interpretation will be acceptable, no other interpretation. You should keep this in mind. Therefore, when interpreting any law, you should interpret it in a manner that it should serve the preamble, the better protection of the interest of consumers, and the section of the consumer law, and the term of the contract should be interpreted by the lawyer in a manner that it should protect the interest of, because it is for the protection of the interest of the consumers, not the service providers or manufacturers or distributors. Against any unfair trade practice, defective goods, deficiency in service, similarly the word deficiency has very strong definition and has been defined in such a manner that each and every aspect comes within its ambit. Like any deficiency means any imperfection, any shortcoming, any inadequacy in the performance of any contract or any law governing parties as to that service. There are about 10 to 20 certain services which have been generally brought in the ambit of service, within the definition of service. Just I was telling you, the interpretation is very important, and the English language is of a great, it is immense wealth. Immense wealth. The proposition before us came to interpret the word any. They said there are only 10 services encapsulated in the law, that is the insurance, housing, airlines and all that, energy, electricity and all that. No. And there was any service which is being availed of by the potential users. Then we said that no. For the purpose of protection of the interest of the consumers, the word any should be given meaning all. Not one, not some. All services governed, all services being availed by potential users has to be given the meaning to the word any. So your interests have to be protected. What are your rights associated? Your right is to know that what is the quality of the goods, what is the quality of the deficiency of service. Your right is to be protected from the unfair and reasonable practice, the unfair trade practice. Your right is to be protected from sale and distribution of any substance which is hazardous to the health. That is all. Again, this is the only law which has given a statutory recognition to the public interest litigation. Public interest litigation, commonly known as PIL, is only the invention of the judicial decision by the Supreme Court and other courts, though there is no statutory definition of statutory inclusion in the Constitution or any other law. This is the only law which provides that any person, because many law students have been filing complaints before me when I was the president of the State Consumer Commission, and I took the cognizance of this and passed very path-breaking and innovative judgments on those complaints made by law students. This is the only law where any person can file a complaint before the Consumer Forum or Consumer Commission, as the case may be, if any other person who has suffered at the hands of the service provider or the supplier of defective goods, any person he can file a complaint on their behalf. He can argue as a friend of the consumer. Any voluntary organization can also file a complaint on behalf of the innumerable consumers who have suffered on account of the deficient services and on account of the defective sales of goods. So this is the only law, section 12, which provides statutory recognition to the public interest litigation, and therefore this is such a law that every one of you can try your luck and can try your hand, that whenever any person comes to you, you may be neighbor or any other person, your friend and all that you have been sold such a defective goods, any kind of goods which is to be used by the consumer needs, any kind of goods, that no, yes, these are the defects, and therefore I want compensation for sale of defective goods. This is the only law where the word compensation appears. No other law has the word compensation in its statute. Compensation for selling defective goods, compensation for having deficiency in services, whatever services you may avail from any source and from any service provider, compensation. Again, the word compensation has a wide connotation. Again, the interpretative skill comes into play. How the word compensation should be interpreted. So there were so many cases in which the word interpretation of the word compensation came to be interpreted in a manner which nobody could imagine. Under the consumer laws, compensation includes, compensation has not one element, it has more than 10 elements, 10 ingredients, the word compensation. Again, the English language plays the trick, the word compensation. It includes the actual loss suffered by you. Suppose if you purchase a vehicle or purchase a thing which is a laptop or something other thing which is of 50,000 value, and if it becomes defective, and time and again you take it to the service centers for removing one defect or the other, then the compensation for selling such a defective goods. To inculcate ethical values into these people, the word compensation was meant to include actual loss, future loss, mental agony, harassment to the consumer for going time and again to there to get the one defect of the other removed, then insult, injury, non-redressal of the grievances at the first instance to the service provider, the seller, or the vendor, and over and above, compelling, forcing a person to go and seek legal remedy by going to the court, consumer court. I have given so much wide connotation to the word compensation that if you have suffered extra loss of 50,000, you are also entitled to get more than 1 lakh, 2 lakhs as a compensation for having suffered mental agony, harassment, insult, injury, from running pillar to post in the government agencies, wherever you TV or other agencies, the government or PSUs and all that it is allowed to make you run from pillar to post to seek one redressal of the grievance or the other. Those elements also come into the word compensation. That's why when we receive complaints, we see that this is my actual loss, this is the future loss, this is mental agony, this is harassment, this is insult, this is injury, this is not all that what I've suffered because I've been going through in time. So if is the definition of what you can. Any shortcoming, any imperfection, any inadequacy. So, just for example, then there is a punitive damages. Punitive damages, this is known because when I took over the last 20 years since 1986, no court, no forum ever imposed punitive damages. And there was another law, 14(1)(b), which was inducted only to give a deterrent effect upon those people who were rich and powerful business houses. And it is a fight between the evident cognac, you see, how to put them into the place and how to pin them down. That was law 14(1)(b), that if one person suffers from the acts of the service provider, the seller or vendor of goods, defective goods, and one who has suffered in the same manner, the innumerable people have to be compensated without having received any complaint from them. First case which I decided to make waves in the international world also was compensating each and every passenger who were traveling by air and there were delayed flights or cancelled flights without any rhyme or reason, without any justification. Only one person filed a complaint to whom I paid 2 lakhs of this compensation for having waited for 4 to 5 hours because the human misery and the might you suffer is not measurable in money, but it is a total compensation which they say that the money may not be the finish for all the diseases, for all the sufferings you suffer, but it may compensate to some extent. So there were about 150 passengers traveling when they directed that now under Section 14(1)(b), which has never been exercised by any court for the last 30 years, since the inception of this law, has to be sent checkers with 1 lakh at their residences by finding out their addresses from the list of the passengers in 1 week. That became vague. That was 14(1)(b). Then there was another, because Catalans, they say there were only 500 years before said, the fear is the basis of all good government and good government, then this is every law has a deterrence also. So this law similarly has a deterrence of punitive damages. As a matter of fact, middle class people and higher people, they don't bother about the suffering silence. They fume and practice the triumph and curse that this is the thing which they are suffering from. Like unsolicited calls and messages were in 2004 when such a large number, every one of us were sitting in the court and used to receive some unsolicited calls or messages, you see. You are in hospital, you are in business meeting, you are anywhere, all hours, 2 o'clock, 3 o'clock, everybody was suffering. Nobody got up the time to file any complaint. They said that there was one lady, advocate lady, she filed a complaint before me, seeking very heavy compensation by enumerating the number of calls and the number of messages he received at all hours. So I took cognizance of that. The question, again, legal questions, interpretation, legal mind, intellectualism came into play. Who is the consumer? The telemarketers said that they are not our consumers. They are not availing our services. Because the consumer is one who hires or avails the services or purchases the goods against consideration and against the separate consideration. Only that person is the consumer. I said no. There is a right of privacy whenever you apply for mobile phone and if you don't read it. This is the right of privacy that the service provider cannot part with any information given by you in the application form so as to your financial status, including your telephone number. So this was a ordering of information to the telemarketers, banks, financial institutions and others that came into for discussion. Said that no, not only the service provider, we are consumers who are it, we are also consumers for the telemarketers because they have parted the information, they have given the money to the service provider for getting information from me. Otherwise, how the hell the bank knows that if he takes my telephone number? So this was an international question. many countries were suffering this malaise. So when I made this interpretation that now every one of us is a consumer for service provider as well as this, I find Airtel 75 lakhs rupees and 25 lakhs rupees the telemarket deals to be deposited in one week, and this created waves everywhere. All the cellular operators association of the world united and they appeared and they hired highest paid lawyers because they can. Poor consumer can't afford a lawyer. Today the legal remedy is becoming average costly every day and night, because even middle class people can't afford the services of a lawyer who are charging very hefty fees. So you people should know your knowledge of a common man. That this is a common law for common man and meant for the weal and good of the common man. Everybody should know law. Basic laws. Our misfortune is that we have doctors, PhDs and all that, they don't know the basic law, the basic rights under the Constitution, basic rights, fundamental rights, rudimentary rights under the law. So you as a student should develop a mind how to interpret it in a way that it should go to serve the purpose, promote the object, and should always be in consonance with those objectives. So then, a problem came because the entire government stood up before me. They said that we can't do number portability. I gave them the order of election that within 1 month we introduce do not call registry. If anybody registers himself that I don't want to receive such call on the telephone, we have to discuss with the do not call registry. This was implemented. But number portability, they said there is a feasibility, there is no non-feasibility of technological problem for not this. But after 3-4 years, they have now implemented number portability. And this government came handy in Canada, where this problem was. And they also said that introduce number portability and do not call registry. One government. Another government which created waves, I'm just telling you the rights, was possible seizure of vehicles by the banks and recovery agents. They will just come and give you beating and take away the keys of your vehicles. If you have not paid 1 or 2 installments of the loan you have taken from the bank or the financial institution. Recovery agents, they said. I said that now, no civilized society can brook such kind of inhuman behavior. Every legal remedy has to be available through legal methodology and through no other means. If you have a contract between the two persons that you will take recovery of possession of the vehicle for non-payment of 2 or 3 installments, take it through legal methodology, not empowering gundas and Muslims and all that. Gave direction to the government of India, Finance Ministry and the RBI, immediately withdraw this provision. Immediately withdraw the gundas and Muslims for recovery within 1 week. And all those who were involved in very strange, very physical cases. That was one man was given so much beating that he had to remain hospitalized for 3 months. And then I got all the 10 recovery agents arrested, sent to jail for 6 months immediately. The law changed overnight. See that had it happened in England and America, from where these banks have got the licenses, these multinationals and very powerful people, had this law been used like a melon in India is being used as if we are not human beings, we are being taken to for a right, they would have got so much beating that their license would have been cancelled. So all the embassy people, the ambassadors, the secretaries, they were outside my court and they were getting this and all that because, hey, such a powerful, you are in a profession which is so powerful, you are in a profession. You are in a profession, similarly you see every day you purchase vehicles. You purchase any kind of vehicle, scooter, be it a car, be it anything, be it a bike. You have some emotional attachment with that also. When you purchase it, it's brand new. You don't expect yourself to visit The garage every now and then for getting one ticket. Brand new vehicle. Brand new vehicle. Every vehicle was being taken 1 month, 4 visits, 5 visits, got this, break through this, through that, through. So, there was a law. They manufactured the defects of the crew. Nothing doing. I said no. There was the requirement of the law. Interpretation of the law, section 2D, defect means any kind of imperfection, any kind of shortcoming, any kind of inadequacy, any kind of inadequacy in the purity and quality of the goods has to